That means that if workers don't like the results of the arbitration, then legally they could not strike and they could not vote it down. The contract would be imposed on them by the arbitrator.
Which side are you on? Which side are you on?
Of another congressional hearing. I love watching congressional hearings. You know me, I am a huge fan of congressional hearings. And so I watched the U.S. Senate Committee on Health, Education, Labor, and Pensions. They had a committee hearing titled Labor Law Reform Part 2, New Solutions for Finding a Pro-Worker Way Forward. And so they had 5 witnesses, a Littler Mendelson attorney, boo, a guy from the Institute for the American Worker, which is an anti-union conservative think tank, a graduate worker from Stanford University who is upset that he has a good union that fights for his wages and stuff because he disagrees with some of the union's political stances, a shop steward at Boeing in St. Louis, and a nurse from Minnesota. And particularly, obviously, you know, there was a lot of interest in, or there's some discussion about the Faster Labor Contracts Act. And so the Faster Labor Contracts Act, right, is Josh Hawley's new piece of labor legislation that is meant to be a pared down PRO Act. And, you know, the PRO Act had a whole litany of pro-worker provisions in it. And the Faster Labor Contracts Act just basically takes out one provision of the PRO Act about mandating arbitration for first contract negotiations. And so that's something the PRO Act did, and so that's what the Faster Labor Contracts Act does. It basically says, like, okay, look, if workers unionize, then it sets a timetable. And if the two parties are not able to come to an agreement, then either party can elect to have mandatory binding arbitration for a first contract. So obviously that means that if you were to go to mandatory binding arbitration, that means that if workers don't like the results of the arbitration, then legally they could not strike and they could not vote it down. The contract would be imposed on them by the arbitrator. And now there was a really good article about this in, I think, On Labor. Let me pull it up. On Labor, what critics of the Faster Labor Contracts Act gets wrong. There's a really good article answering critics, but there's an industrial democracy concern there. Obviously, if you have binding arbitration and workers can't turn it down, well, then that kind of takes away the workers' voice a little bit, right? And so somebody asked, the Senator Cassidy, the chair of the committee, asked the Boeing worker who was there what he thought about that provision, or what he thought about that. He didn't associate it with the Faster Labor Contracts Act, but he asked about, would you be in favor of a law that could potentially impose binding arbitration over the no vote of your fellow workers?
Mr. Arnold, I'm told that the striking workers that you worked with had voted down 2 tentative agreements between IAM and Boeing, one of which IAM called a landmark contract. Now, we heard in our last hearing about the role of arbitration as a potential solution to a first contract. But as I understand, arbitration could take workers out of the process by removing the need to ratify a contract. Put differently, if the leadership came up with a contract, arbitration said, yep, this is it, then the members could not reject it. As you mentioned, they've already rejected 2 things that have been offered. What would happen if the IAM workers lost that ability to ratify a contract?
Thank you for your question, Senator. It is my understanding that in our Constitution, our members get to vote on the contract, period.
If you go to arbitration, my understanding is that if you have arbitration and it's an agreed upon, then that becomes the contract, at which point the workers would not have the ability to reject.
If that's the case, then that would be removing the democracy from the workplace, which is the whole point of a union, giving the worker a say.
That would defeat the whole purpose of having a union. And so it was very funny seeing a worker from Josh Hawley's state saying, your supposedly pro-labor bill is it would defeat the purpose of having a union, right? And so then there's it's fair enough to say that, and it's funny to point that out, that one of Hawley's union constituents is like not in favor, in principle, it doesn't seem, of this of his big pro-labor bill, and so it's funny to be able to say that, but it's not as bad as it sounds.
Hey, 5 seconds. Just wanted to say that this is only possible because of our donors. If you want to see more of this, then consider donating yourself at tvlr.fm/donate.
This guy has, there's a blog on labor.org, and Tasha Shariari Parsa wrote an article titled, "What Critics of the Faster Labor Contracts Act Get Wrong." He talks about how the threat of arbitration doesn't actually take away workers' leverage. It pressures both sides to reach agreements and tends to result in higher wages. The act will also encourage new organizing by effectively guaranteeing a contract on the horizon for those who do. Here, I want to address the most common substantive objection to the Faster Labor Contracts Act, that we shouldn't place federal bureaucrats in charge of contract negotiations. Whether that view stems from faith in free contracting, a commitment to industrial democracy, or skepticism about an outside adjudicator's ability to determine what's best for a specific workplace, I take it that many across the political spectrum, though not all, are wary of arbitrators deciding labor contracts. But this critique misunderstands how first contract arbitration works as a rarely used last result. As Matt Brunig explains, the 70% of first contract negotiations that currently go well will be virtually unaffected by the Faster Labor Contracts Act. The threat of arbitration just helps get the other 30% moving. That's because neither party wants to arbitrate. Arbitration has fees. Arbitration introduces uncertainty. And compared to unions and employers, arbitrators have less intimate knowledge about the specific workplace that helps produce a workable agreement. These are similar to the downsides of a civil trial. And only 1% of civil cases in federal court go to trial. Just as the threat of trial encourages fair settlements, especially between parties who with otherwise unequal bargaining power, the threat of arbitration brings employers to the table in earnest. But almost always, the trial or arbitration does not transpire. The evidence backs this up. British Columbia in Canada offers a useful comparison. Its labor code allows first contracts to be decided by an arbitrator if bargaining and mediation fail. Over a 30-year period, only 0.5% of first contracts were imposed by an arbitrator. The rate is higher in other Canadian jurisdictions that skip mediation, another reason to think that the FLCA, which requires mediation, was thoughtfully drafted. What's more, even in the rare cases where the arbitrator does step in, they're penciling in a provisional agreement. Instead of the current default, which is no agreement, aka whatever the employer wants, the arbitrator supplies a baseline for continued bargaining and a fallback in case negotiations break down. If the arbitrator gets something wrong, the parties can amend or even fully scrap the arbitrator's terms. Finally, when it comes to bureaucratic intrusion, the status quo is worse. Instead of keeping employers and unions focused on bargaining as the FLCA would do, the current rules force the parties to continually return to the board to quarrel not over substance but over the meta question of whether their negotiations are proceeding in good faith. It's like arguing about arguing, an unproductive distraction. Once the board applies the enforcement of a bargaining order, we might say the parties start arguing about arguing about arguing. By leveraging the threat of arbitration, the FLCA nudges parties to bargain in good faith instead of bringing in a third party to directly micromanage negotiating behavior. So that, I was initially actually kind of skeptical about the Faster Labor Contracts Act, but I felt like this article was really, really good and really, I don't know, I was totally convinced by it. And so I would love to see the FLCA pass, because it does seem like, especially after reading this article, it really feels like, if the question is status quo or implementing the Faster Labor Contracts Act, we should probably implement the Faster Labor Contracts Act. And so we'll see what happens there, and we'll keep an eye on it, obviously. And so even though I disagree with the Boeing worker, it is funny to say, to play that clip where he says, no, your bill defeats the whole purpose of a union.
You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fm.